Good morning. Today is May 6, 2022. The time is 8:30 a.m. The Commission has set this time for an evidentiary hearing in the case captioned as "In the matter of the application of Missouri American Water Company for a certificate of convenience and necessity, authorizing it to install, own, acquire, construct, operate, control, manage, and maintain a water system and sewer system in and around the city of Eureka, Missouri." It is our file number WA-2021-0376 and also includes the sewer system case, file number SA-2021-0377. Previously, on January 21st and 22nd, January 20th and 21st, evidence was presented to the Commission in this matter. The purpose of today's evidentiary hearing is to collect additional evidence pursuant to the Commission's order granting request to reopen the record issued April 21st. Per that order, today's evidence shall be limited to that related to the Arbors of Rockwood Community Improvement District. My name is Ken Sire. I am the regulatory law judge presiding over this hearing. The hearing is taking place in the Public Service Commission hearing room, room 310 of the Governor Office Building in Jefferson City, Missouri. However, witnesses will also be participating over the internet via Cisco WebEx. So let's have counsel for the parties make their appearance, beginning with Missouri American Water.
Thank you, Your Honor. Dean Cooper from the law firm of Bride and Swearingen, England, PC, P.O. Box 456, Jefferson City, Missouri 65102, appearing on behalf of Missouri American Water Company.
All right, public counsel.
Good morning, Your Honor. Lindsay Van Gerpen from the Office of the Public Counsel, P.O. Box 2230, Jefferson City, Missouri 65102.
Okay. And the staff of the commission.
Karen Bretz for staff, B-R-E-T-Z. Address is 200 Madison Street, 8th floor, Jefferson City, Missouri 65101.
All right. For those in the hearing room, I ask that everyone silence all cell phones and mobile devices. If you are in the hearing room and also logged on to WebEx, I ask that you log off WebEx to avoid feedback and other potential audio issues. Also, for those in the hearing room, please be cognizant of when your microphones are on, indicated by a lit green light at the base of the microphone, and when they are off. For those connected via WebEx, I ask that you mute your microphone when not speaking. Also, the court reporter today is not present in the hearing room, but is instead participating via WebEx. Therefore, it is important that you speak into the hearing room microphones so that she can record all of the proceedings. Do the parties have any preliminary matters today? All right.
Judge, I didn't realize that the court reporter was going to be on WebEx. How should we handle exhibits then?
I think we all have access to those exhibits.
Since they're entered into EFIS already?
Right,
Okay.
right. And then as long as, if they are not already logged or entered into EFIS, as long as they are emailed to the exhibits at psc.mo.gov email address. All right. Are there any changes to the joint order of witnesses and cross-examination filed on Wednesday, May 4th? Okay. So.
Judge, this is Chairman Sylvie.
Yes.
I would just like to note that I am present as well as Commissioner Holzman, and I'm not sure if any other commissioners are present.
Yes, Commissioner Coleman is here.
Thank you, Commissioner.
Commissioner
Thank you. Thank you, Judge.
I'm sorry, who is that?
I believe Commissioner Coleman and Commissioner Holzman are also present.
Okay, thank you. All right, so according to the the joint order of witnesses. Staff will be calling Craig Sabo, Kurt Gately, Amanda McMillan, and then Missouri American Water would call Sean Flower and Brian LeGrand. So is that correct? Okay. As far as the numbering of the exhibits, previously exhibit numbers 1 through 99 were assigned to Missouri American Water Company, 1 through 199 to staff, 2 through 299 to Public Counsel, and 300 to 399 to the Commission. So any new exhibit should follow that numbering. All right, so Ms. Bretz, would you like to make an opening statement on behalf of the staff?
Yes, thank you. Good morning. May it please the Commission. I'm Karen Bretz for Commission staff. Thank you for reopening the record in this case to hear evidence whether residents of the Arbors of Rockwood subdevelopment will pay twice for their water system if the sale of the City of Eureka water systems to Missouri American is completed.
Excuse me, Ms. Bretz, is that microphone on?
Yes.
Okay, I just want to make sure.
Briefly, the Arbors subdivision is on the north side of I-44, just east of Six Flags. It's a brand-new subdivision. There are 528 home lots, and according to Mayor Flowers' testimony, 405 occupancy permits have been issued to date. The residents in the Arbors are subject to a Community Improvement District, or CID. Sections 67.1401 through 67.1571 RISMO provide for the formation of CIDs and describe how they operate. Depending on the amount of street frontage, homeowners in the Arbors are annually assessed between $500 and $800 annually to reimburse the developer's costs, which include the costs of constructing the water system. The CID is authorized to levy these assessments for up to 32 years from the date the City of Eureka ordinance was passed. So potentially, Arbors residents will be paying these assessments until 2048. Staff's opinion is that residents of the Arbors will pay twice for the water system serving their subdivision if the sale to Missouri American goes through. Through their CID assessments, residents are currently paying the developer's cost of installing the water system. Documents filed in EFIS from the State Auditor's Office and the St. Louis County Department of Revenue show that Arbors residents have been paying these assessments since 2018. On their real estate tax receipts, these assessments are listed as other charges. This is one time that the Arbors residents will be paying for their water system. If the sale to Missouri American is completed, the appraised value of the water system will be included in Missouri American's rate base. Therefore, all Missouri American customers, including residents in the Arbors, will pay for this appraised value through their rates. This is the second time that Arbors ratepayers are paying for their water system. Brian LeGrand of Missouri American states in his testimony that Arbors residents will not pay twice. His reasoning is that under the appraisal statute, fair market value establishes rate base, and regardless of whether the value of the Arbors water system is considered contributed property, the fair market value for the entire transaction is still $28 million. Mr. LeGrand further states that customers in the Arbors will pay the same rate as all other Eureka customers. And this actually bolsters staff's arguments because it establishes that Arbors residents are paying fully for Missouri American's investment in the system. Mr. LeGrand overlooks that Arbors residents have been and will continue to pay annual assessments to the CID. The parties have briefed the issue whether the Commission must make a necessary or convenient for the public interest finding when a purchase is made pursuant to the appraisal statute. Staff and OPC's position is that the appraisal statute does not abrogate the Commission's duty to make this finding. Missouri American's position, of course, is that the Commission must blanketly accept the Missouri American/City of Eureka appraisal. The necessary or convenient standard safeguards ratepayers to help ensure that their rates are fair, just, and reasonable. As we've seen in this case, the necessary or convenient for the public interest standard provides a vital check and balance. It ensures that people are not paying twice for the same system. Staff has subpoenaed Craig Sabo, an employee of the City of Eureka, and a board member of the Arbor SID to be present today. Staff's other witnesses, Craig Gately and Amanda McMillan, are also available for cross-examination and commissioner questions. Thank you.
Thank you. Ms. Van Gerpen, would you like to make an opening statement?
Just very briefly, Your Honor.
I'm sorry, Judge. This is Chairman Sylvia again. Are we going to have an opportunity to question the opening statements?
I'm sorry about that. Yes.
Thank you. I have a couple of questions.
Do any of the other commissioners have any questions for Ms. Bretz?
Yes, Judge. Ms. Bretz, thank you for your opening. A couple of questions. Did the residents of this subdivision have an opportunity to vote in the election?
Yes, they voted as the other residents of the City of Eureka did.
And did the ballot language include the sales price of $26 million?
Yes, they did, and it was actually $28 million.
$28 million. Okay, thank you for that correction. What portion of the CID that they're paying, their annual CID fee, what portion of that is specifically related to the water as opposed to the streets, the sidewalks, and the other things covered by the CID?
Amanda McMillan might be able to better answer that question, but staff did a back of the napkin formulation of how much they will be paying. And staff estimates that the amount that they will be paying to reimburse the developer is the same as what staff assigned as contributed plan, which is $2.9 million. But you're asking how much of their annual assessments will be put towards the paying off the developer?
Specifically for the water system, because my understanding of how CIDs operate is there's other costs included there that the developer's being reimbursed for, the streets, the curbs, the sidewalks, whatever would have been included in that CID to begin with. So of the aggregate costs, how much of that are specifically related to the water treatment center?
As I recall, and it's in the development agreement, which we will ask to be admitted into evidence, I believe the entire total is $3.4 million. And so approximately 2.9 of that will be for the water system.
Okay. So if the commission were to determine what relief is staff asking for? Are you asking for us to just reject the sale outright? Or is there a way in which the commission could craft an order for the sale to proceed, but protecting the interests of that particular neighborhood as it pertains to double pay?
I believe the staff's position is that it's an all or nothing situation, and that the language of the appraisal statute says that you must either accept it or reject it. And so we're asking for the commission to reject entirely the Missouri American application.
So there are approximately 500 and some lots in this neighborhood. Is that what your statement said?
500 and some change, yes.
500 and some change. So how many lots are there in Eureka at large?
I'm not sure entirely. I recall testimony from, I think it was from Mayor Flowers, that he stated that the people living in the Arbors development is approximately 10% of the population, of the number of homes that are would be potentially Missouri American customers.
So if it's an all or nothing proposition and we have no authority to find a middle ground or to specifically carve out that neighborhood, you're asking us to reject an entire application based on 10% of the population. Is that an accurate assessment?
Well, I mean, we had 2 days of hearing in January too, and we believe there's other reasons why the application should be rejected. At this time, we're just addressing the Arbors, the Arbors issue. We believe that there are other reasons why the application should be rejected, as we described, as we put testimony on in January.
Sure, but as it pertains to this hearing today for this one specific issue, all or nothing based on 10% for this argument.
Yes, of course, Missouri American is free to come back and submit another application.
And how long would that take?
We could ask for an accelerated schedule, I would think 60 days. 60 days, we could come up with another recommendation. Staff could come up with another recommendation.
Okay. Thank you, Ms. Press. Thank you, Judge. No further questions.
Thank you.
Are there any questions from the other commissioners?
No questions, Judge. No questions.
All right, thank you. Okay, Ms. Gerben.
Good morning, and may it please the Commission. My name is Lindsay Van Gerpen, and I represent the Office of the Public Counsel. The OPC continues to request that the Commission deny Missouri American Water Company's application for a Certificate of Convenience and Necessity in regards to the acquisition of the City of Eureka, Missouri's water and sewer systems. The OPC maintains the positions that it took in its initial and reply post-hearing briefs. Specifically, that the Commission should deny the requested CCN because Missouri American Water Company plans to pay too much for these systems, and its plans to provide water service to Eureka through a new pipeline means that this acquisition simply is not in the public interest. Today, we're here to explore the additional fact that the residents of the Arbor subdivision will likely pay twice for parts of their water system if Missouri American Water Company completes this purchase. These payments will come once through a Community Improvement District special assessment and once through their Missouri American Water Company rates. Although the OPC does not dispute that Missouri American Water Company is qualified and has the financial ability to provide water and sewer service to the citizens of Eureka, these facts will further support the OPC's position that this acquisition, as proposed, simply is not in the public interest. And for these reasons, the OPC continues to request that the Commission deny the requested CCN. Are there any questions?
Any questions from the commissioners?
Thank you, Judge. This is Chairman Sylvie. I would have a question.
Go ahead.
Thank you for your opening statement. So, since you mentioned it in your opening statement, you're contending that Missouri American is paying too much for the system?
Yes, that's correct.
And they're paying it to the city of Eureka, correct? Not to an individual developer?
That is correct.
And the city of Eureka, it seems like this is a little bit of a different situation than an acquisition to a private developer, because the citizens, they're essentially paying the citizens who are going to be receiving the service through their elected city council and dispersing those funds. Is that an accurate assessment? So they're overpaying to themselves?
I'm not sure that I would agree with that, because the citizens of the Arbors will still continue to pay for their water system through the CID as well.
But you also agree that they participated in the election, which stated the amount of the sale,
Yes,
and that the proceeds of the sale will go to the city, which will be able to be appropriated by their elected representatives?
yes.
Okay, thank you. Thank you, Judge.
All right, are there any other questions from the commissioners? All right, thank you, Ms. Van Gerpen. I apologize. All right, Mr. Cooper, would you like to make an opening statement?
Thank you. Before I go, I guess, into my opening statement, I did want to respond to one thing that Ms. Brutz stated near the end of her opening. She was asked about the timing it would take to bring up another application before this commission. And she referenced, I think, the 60 days that is sort of aspirational for the staff to file a recommendation from the time an application has been filed with the commission. I don't know how many cases that actually happens in 60 days, but more importantly, as has been discussed in this case when we were here before, the sale of the system by the city of Eureka requires a public vote. That public vote that passed calls for a purchase price certain. So I think that if we're talking about some sort of situation where we came back to the commission with some other purchase price, you're talking about placing another resolution on the ballot and an election and that process before you ever get around to thinking about coming back to this commission. So I think that it is a much longer time frame than just coming back with a second application. That having been said, I do want to say that the issue we're discussing today with the Arbors is largely a continuation of an issue that has been discussed previously. The Arbors development was specifically discussed in this case to include staff's calculations, and its staff recommendation was incorporated in its testimony. There was cross-examination of the staff witness about the Arbors, and Missouri American addressed the Arbors in its initial brief. Now, that focused on the fact that the Arbors was being treated as a contributed property or contributed plant by the staff. And in fact, specifically, that's what Missouri American's initial brief talked about, with the impact contributed plant, we believe, should have on fair market value, which is none. But more to the point, as can be seen in the testimony, Eureka has had a public question and answer website associated with the wastewater and water properties and the sale process that specifically addressed the Arbors situation, the Arbors CID, in fact, situation for some time. Missouri American witness LeGrand points out that the staff made specific reference to the city question and answer site as early as October 1st of 2021 when the staff recommendation was filed. Throughout the case, staff has been aware of the Arbors assets and the fact that they were contributed to Eureka, and as I said earlier, took this into account in its recommendation. And in fact, Mr. Gately's testimony in today's hearing specifically indicates that staff's recommendation remains unchanged as a result of the CID information. Now, more importantly, whether there is a community improvement district in place to recover a portion of development costs related to property contributed to a city, or all development costs are assumed to have been recovered or not in some way, some other way, the issue is the same for this commission. That is, once the assets are owned by a city, does the path of the city's acquisition matter in regard to the fair market value of the assets owned by that city for purposes specifically of Section 393-320 RISMO? Again, Missouri American believes the answer is that it does not. in accordance with section 393, 320.5, subsection 1, the lesser of the purchase price or the appraised or fair market value, excuse me, together with the reasonable and prudent transaction, closing, and transition costs incurred by Missouri American shall constitute the rate-making rate base for the Eureka system being acquired by Missouri American. The assets referenced by staff are owned by Eureka, are currently in service, and are used and useful for the provision of water services to Eureka residents. Nothing in section 393, 320 references or creates an exception for contributed property in the case of a municipal system. Now, this does not mean that the concept of net book value is completely ignored by section 393, 320. If the small water utility is a public utility subject to Chapter 386, and the small water utility completed a rate case prior to the acquisition, the Commission may utilize the net book value determined by the Commission in its decision as to the rate-making rate base. However, again, that provision is not available where the small water utility is a municipal system. That different approach could be for one or all of several good reasons. It could be because of the difficulty in establishing a net original cost for an unregulated system, because the consolidation of small water and sewer systems with large systems should be encouraged, or perhaps that's because in the case of a municipality, as citizens, the customers are receiving value in that the city can use and apportion its sales proceeds as it sees fit for the benefit of the city and its citizens. Now, I would add to my perhaps list one more item. A fourth-class city may sell property pursuant to the powers granted by section 79.010, but this power must necessarily be exercised in conjunction with the Missouri constitutional provisions. Article 6, Section 25, and Section 23, for that matter, prohibit a city from a grant of public money or property to any private individual, association, or corporation. As a result, a city may not donate to private businesses or charities, give away assets, or convey assets for nominal consideration. And I would reference, as a good summary of this situation and the case law surrounding it, I would reference you to an AG opinion 98-96, which was issued on July 5th, 1996, and can be also cited in Lexus's 1996 AG Lexus 77. And I have copies of that, Judge, if you're interested. If the city were to give its water assets to Missouri American, or the arbor assets to Missouri American for something less than fair market value, such an act would appear to violate the Missouri Constitution. Now, I would also like to talk a little bit about the sort of the perspective, the proportions involved here in regard to the size of the arbor subdivision. There are, as Ms. Brett said, about 405 water customers currently in the arbors area. This compares to approximately 4,100 total Eureka water customers and approximately 340,000 Missouri American water customers in St. Louis County, the district of which the Eureka water customers would become a part. The $2.9 million construction costs associated with the Arbor's water system assets that we're talking about today compares to a water rate base for the St. Louis County district of approximately $1.2 billion as of December 31st of 2020. The portion of any revenue requirement associated with that $2.9 million that one could even argue would be recovered from the Arbor's water customers through MAWC rates would be extremely small. Finally, I'd leave you with a couple of questions. Staff's argument again is its position that the 405 water customers in the Arbor's development could pay twice for the Arbor's water system. As discussed before, MAWC believes this concept is not applicable to a municipal system. However, even if it were, if the sale does not go through, the assets stay with Eureka, and the Arbor's residents continue to pay the same water rates as other Eureka customers. Would staff still say that those customers are paying twice? What if in the absence of a sale to Missouri American, those Eureka water rates are similar to or even higher than the Arbor residents would have paid to Missouri American. Would staff still argue that they are paying twice if the system is acquired by Missouri American, but not if the sale falls through and they pay higher rates? It's just a fact that the crossover of assets from a municipality to a regulated investor-owned utility necessarily create sort of the overused phrase of apples to oranges comparison. Net original cost and contributed plant are terms applicable to regulated utilities and have nothing to do with a municipal utility accounting, and more important, nothing to do with the fair market value of those municipal assets. The issues raised in this hearing do not change the arguments Missouri has made in its initial and reply briefs, and Missouri American asks that the Commission apply Section 393-320 as written, grant Missouri American certificates of convenience and necessity to provide water and wastewater service within the proposed service area, subject to the conditions described by staff, and establish the rate-making rate base for the systems acquired at amounts equal to the fair market value. Thank you.
All right. Chairman Sylvie, do you have questions?
Thank you, Judge, I do. Thank you for your opening. So you referenced the 405 customers in the subdivision, roughly 4,100 customers total in Eureka, and then 340,000 in St. Louis County at large?
Approximately, yeah. Perhaps a few more than 340,000, but that's pretty close.
Okay, so just so I'm clear, if this acquisition were to go through, then the rate base for the citizens of Eureka would become 344,000 people spread. I mean, they would all be paying the same?
The number of customers in the St. Louis County district would would be approximately 344,000, correct?
Would they all be on the same rate?
Well, within that number of customers, there are, and I can't remember the rate designations, but there would be some differentiation. There's rate A, there's rate J for industrials. Mr. LeGrand could probably give a better rundown. I know he could give a better rundown than I can of the different rates, but largely. Go ahead.
Let me rephrase. So, sure, yes, respective of different rate classes, would the $2.9 million that's at issue today be spread across 340-some thousand people as opposed to just the 4,100 people in Eureka?
Correct. Yes, Chairman, that would be our position.
Okay, so your contention is the actual amount of double payment would be very small because 340,000 people who aren't currently bearing that cost would also be bearing that cost after the acquisition.
That's correct, yes.
Okay, thank you. Thank you, Judge.
Do any of the other commissioners have questions?
No questions, Judge.
All right. Thank you, Mr. Cooper.
Actually, Judge, I apologize, Chairman Sylvie again. I do have one additional question. So, we have the election that occurred. Is the record, does the record show what the results of the election were specifically, or just that it was a majority that approved the sale?
No, I believe, Chairman, that I don't remember the exact count, but I believe that our direct testimony provides the exact count. Yeah, our direct testimony in the first part of this case. And I'm sure we could come up with that pretty quickly.
Okay, and for the specific issue today, I don't recall seeing in the record, would it be possible to get the precinct results for this area where the CID is into the record?
I can certainly look. I think whether it comes into the record or not is a question for yourself and the judge, but certainly we can see if we can come up with that information, Chairman.
Okay, thank you. Thank you, Judge.
All right, thank you, Mr. Cooper. All right, Ms. Bretz, call your first witness.
Our first witness is Craig Sabo.
All right, Mr. Sabo, are you, and he's testifying via WebEx, correct?
That's my understanding.
All right, are you there, Mr. Sabo?
I'm present.
All right, thank you. Would you raise your right hand to be sworn in, please? Thank you. Do you solemnly swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Ms. Bretz.
Thanks. Good morning, Mr. Sabo.
Morning.
I'll turn this around so I can both look at you and speak into the microphone. It's a little awkward. You're an employee of the City of Eureka, is that correct?
Yes.
And what's your title?
City administrator.
And what's your job responsibilities in a nutshell?
Oversee the day-to-day operations of the city. Provide managerial support and oversight.
And you're also a board member of the Arbors of Rockwood Community Improvement District, is that correct?
Yes.
How long have you been a board member?
Since its formation, roughly 5 years ago.
If I said 2016, does that sound about right?
Yes.
Okay. And do you have an officer position in the CID?
Yes, I'm secretary and treasurer.
You're currently secretary treasurer of the CID?
Yes.
Is Barb Flint also an employee of the City of Eureka?
Yes, she's our finance director.
And she's also a board member of the Arbors CID?
Yes.
Does she have a position other than being board member? Is she an officer as well?
No.
Okay. Staff subpoenaed you to be present today, correct?
Yes.
And staff asked you to bring some documents with you?
Yes, which were provided.
Correct. We found out you were going to be appearing WebEx, and you were gracious enough to provide these documents beforehand, and you made those available to staff, right?
Yes.
I'll say for the record that staff distributed to the other parties and also filed into EFIS these documents. And what you have marked as document 1 is a copy of Ordinance 2394, which was passed by the City of Eureka's Board of Aldermen, and it establishes the Arbors of CID. Is that correct?
Yes.
You're familiar with that ordinance?
I am.
And what you sent to us is a true and correct copy of that ordinance?
Yes.
And then what you marked as document 2 are the resolutions passed by the Arbors CID?
Yes.
And you're familiar with those resolutions?
Yes.
What you sent to us are true and correct copies of those resolutions?
Yes.
And what you marked as document 3 is the development agreement between the City of Eureka, the developer, and the Arbors CID?
Yes.
And you're familiar with that agreement?
Yes.
And what you sent to us is a true and correct copy of that agreement?
Yes.
Staff also asked you to bring the receipts and financial records related to the water system at the Arbors. Is that correct?
Yes.
And you wrote to me that that information was contained in what you marked as document 2U, correct?
Yes.
Judge, we would ask for the these subpoenaed documents to be admitted as, I think, Exhibit 100. Is that the correct numbering?
I would suggest that we make that Exhibit 110, which I think is the next available exhibit number.
Sure.
So all three of those, or all of those documents, or
Yeah.
just document one?
All the documents.
Okay. So what's essentially document 1, 2, and 3, that collection would be exhibit number 110. Are there any objections to that? All right. Exhibit 110 is admitted.
We don't have any other questions, Judge.
All right. Ms. Van Gerpen, do you have any questions?
No questions, Your Honor.
All right, Mr. Cooper.
No questions, Your Honor.
All right, are there any questions from the commissioners? All right, hearing none. I do have some questions myself. All right, so Mr. Mr. Sabo, you are currently a member of the Board of Directors of the SID, correct?
Yes,
And as you testify here today, are you representing the district, the city, or some combination of both?
presumably both.
Okay. This community improvement district, did the development of that area start before the creation of that SID?
Legislative consideration preceded it for the zoning.
But actual shovel in the ground, not before creation of it?
I can't speak as to how the timing of those two met.
Okay,
Certainly close,
okay.
but not necessarily. I can't nail the timeframe.
Has that subdivision, has that development been completed?
No,
Are there still lots for sale?
it's approximately 80% developed.
And as far as
With
lot,
lots-
I'm sorry,
With lots for sale, yes,
okay, so approximately 20% of the lots are still for sale?
correct.
Okay. What we have, what has been filed in the EFIS filing system as document 2U, 2 in the letter U, are receipts for the development. So I'd like to draw your attention to that document.
I have it available.
Okay. Are any of the projects that were developed under the CID, have they been sold or are they to be sold to Missouri American Water?
Well, the water and sanitary sewer component, including infrastructure located on site, such as a well and tank, and various appurtenances such as softening equipment, disinfection, fluoridation, and the like.
And as those portions of the development were constructed, were they transferred to the city?
Upon completion and service being provided by them, yes.
And logistically, how was that done? Was it done by resolution?
That would have been inspection by staff and any consulting engineers. Same as with any other subdivision.
Okay. So you had mentioned that the subdivision is roughly 80% completed. So has there been a certificate of substantial completion submitted to the city?
I don't know. Just those components would have been accepted. I generally view substantial completion as the entire development, including all other forms of infrastructure such as streets, and that would not be the case in light of the subdivision still being under development.
All right, I'm sorry, I'm not sure why the microphone turned off there, but if I can draw your attention to the amended petition for creation of the SID.
Which
Do you have a document number for that?
I'm sorry,
Do you have a document number for that?
give me a second here. It would be in that document 1 that was filed with the subpoena in EFS.
Thank you.
Approximately 6 pages in.
This is the ordinance.
It says it's 6 pages in.
This isn't the ordinance. Apologize, one moment, please. I have this.
Okay. On the 3rd page of that amended petition, it states there's a section for the estimate of costs and improvements. And it states that the estimated costs are approximately $3,413,574. In the annual report that was submitted to the state auditor's office, it also lists obligations roughly in that amount for the fiscal year ending June 30th, 2021. So can you tell me when those obligations were issued, on what particular date?
One moment, please.
Sure.
Which document that is? Exactly. This one. Apologize, many documents.
Of course.
Based on resolution 21-001, they appear to be in 2016, throughout the various months throughout 2016.
So not issued all at one time.
They were submitted in April of 2017, but not incurred all at the same time, of course.
And what form were those obligations issued? In what form were those obligations issued?
My understanding is that there was a note or notes issued, carried by the developer.
And issued to whom? To what entities?
Brewster Road LLC, the entity of developer formed in connection with the project.
Okay, if I could direct your attention, still within that document, to you, roughly page 7 of 48.
Okay.
At the top of that page, it is headed Parkfront Group LP, PARC, FROONT. And then the next line, HTV CID reimbursable project cost.
I see that, but I'm not familiar with that entity.
Okay. But as if you can take a look at that page, would you agree that this is essentially what those debt obligations paid for, the $3.4 million?
Yes.
And so it's payments to roughly a half a dozen companies that contributed to the project, and the majority of it was for water service. Would you agree?
Yes.
And then $590,000 on streets and $48,000 on an asphalt trail.
Yes.
Okay. So were there, so cost, and I know the ordinance talks about lawns, trees, other landscape, traffic signs, signals, drainage, et cetera, storm and sewer systems. But at least out of this 3.4 million, none of that was spent on lawns and trees and so forth, correct?
Correct.
All right, I believe that's all the questions I have at this time. All right, Ms. Van Gerben, do you have any recross based on my questions
Nothing, Your Honor.
or the commissioner's questions? All right, Mr. Cooper?
Just a couple for clarification, Your Honor. Mr. Sabo, you were asked some questions about the status of the subdivision, and I think you mentioned that it was about 80-20, about 80% of the lots sold and about 20%, I guess, have not yet been sold. Is that correct?
Yes,
Would the collection lines for the sewer system and the distribution lines for the water system already be in place in regard to that 20% of the lots that have not yet been sold?
it is possible that a few mains have not yet been extended. I'm not certain.
And it was mentioned, the sewer system was mentioned, or perhaps I would say it was not mentioned as a part of the costs being recovered through the CID. Is that correct?
Yes.
That's all the questions I have.
All right. Ms. Bress, do you have further questions?
Nothing, thank you.
All right. Can this witness be excused? All right, thank you, Mr. Sabo. You're excused.
Thank you.
All right, Ms. Bretz, call your next witness.
Staff's next witness is Kurt Gately.
All right, Mr. Gately, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead, Ms. Bretz.
Mr. Gately, would you please state and spell your name?
Curtis, Curtis Gately, Gateley.
Where do you work and what's your job title?
I work for the Public Service Commission. I'm the manager of the Water, Sewer, and Steam Department.
Are you the same Kurt Gately who prepared testimony? It's called direct testimony of Kurt G. Gately with exhibits attached.
Yes,
Do you have any changes or corrections to your testimony?
I do not.
If I asked you those same questions today, your answers would be the same?
Yes,
And your testimony is true and correct to the best of your knowledge?
yes,
Judge, we would ask for Mr. Gately's testimony to be, and the exhibits, the attached exhibits to be entered as I believe, is that, we're at 111 now?
Yes, that's correct. Is there any objection? All right, I'm seeing shaking heads, so with no objections, Exhibit 111 is admitted.
We tender the witness for cross-examination.
All right. Ms. Van Gerpen?
No, nothing from OPC.
All right, Mr. Cooper? All right,
Nothing at this time, Your Honor.
all right. Are there any questions from the commissioners?
No questions, Judge.
All right. Mr. Gately, I have a couple of questions. For this particular subdivision, why is it staff's position that the residents in that subdivision will pay twice for their water system?
right now, those customers, it's my understanding, have been paying to reimburse the developer for the assets and will continue to pay for several years. In addition, the assets, as part of the purchase of Eureka, will go into rate base, for which those customers will continue to pay that rate base and the return on that investment. So unlike other customers for whom Missouri American might construct some infrastructure, some plant, and then recover that and recover a return, for those particular customers, they'll be subject to the normal situation for customers plus an additional tax, that assessment.
Okay. If those purchasers of the lots in that subdivision, rather than paying an assessment over the years, had paid for those development costs up front as a part of the purchase of the lot, would staff still have that same position?
No, the typical development situation, developers, of course, are trying to maximize their profit. They're trying to recover any of their expenses through the sale of lots in a development. They're subject to market forces. They may not be able to recover as much as they would like, or all of it, but it is expected that folks who are purchasing a lot that aren't subject to a special district like this, that yeah, they will have already helped to pay for some portion of it in the purchase of the lot. Our position would be different if it was an average situation, yeah. These assets being contributed to Eureka and then sold to Missouri American is a unique situation for me. I've never encountered it, and the staff members I've talked to haven't encountered one in this particular situation before.
But is it common for developers to construct assets that are then donated to the city, to the municipal water or sewer system?
That's the more typical situation that I'm familiar with, yes.
All right, I don't have any further questions. Ms. Van Gerpen, do you have any follow-up questions?
Nothing, Your Honor.
All right, Mr. Cooper?
Yes. Mr. Gately, I think I heard you say that in a situation where there was no CID, where a developer constructed a system, tried to, maybe did, maybe didn't, recover costs through the sale of the lots or the lot prices, that staff would view that differently than the CID situation. Is that what you said?
Yes.
So in that latter, or in that situation where the assets were contributed, and there's no CID, contributed by developer, and there's no CID, you would not view that as contributed plant?
I mean, I'm not an auditor, so I don't calculate such things. That refinement of that kind of question would probably be better for Amanda McMillan.
Okay. And what causes my confusion is that in this case, staff suggested that it didn't know about the CID at the time it did its recommendation, and yet it did view the Arbor's construction costs as contributed plant, correct?
When we initially asked Missouri American and DRs for what the contributed plant was, the response indicated there was none. It's my understanding that staff found out about the contributed plant for the Arbors when they made the effort to go to the city and review records and discuss the situation with the city. Again, I wasn't part of that particular piece of the investigation, so I'm speaking to my understanding of it.
But it was still identified as contributed plant at that point, correct?
Yes, in our recommendation it was.
Okay. Now, the judge asked you about the concept of the residents of the arbors paying twice, and you were talking about both the CID assessments and then whatever might be in their rates if Missouri American purchases the systems. Now, you're not suggesting that the arbors development would have its own separate rate from the rest of St. Louis County, are you?
Rates would be determined at the next rate case, so I can't answer that question for sure, but at this point, no, staff is not making that contention.
Yeah, and staff, in fact, has recommended in this case that if the transaction proceeds, that all of Eureka's customers should be, become a part of the St. Louis County water rate-making district, correct?
I would have to look back at my testimony for the sponsoring of the staff rep.
But let's assume that's the case. If it is, wouldn't the amounts associated with the Arbor's water system be essentially spread throughout the St. Louis County rate-making district?
Yes, the total amount of the purchase of Eureka, in addition to the money spent to remediate Eureka's assets, would be spread amongst all of the customers in that rate district, including the assets of Arbors.
Yeah, which is several 100,000 customers, right? Or at least a couple hundred.
Yes,
Plus.
more than that, yes.
Yeah, okay. Thank you.
All right. Ms. Bretz, do you have redirect?
No.
All right. Thank you. Ms. Bretz, call your next witness.
Our next witness is Amanda McMillan.
Thank you. Would you raise your right hand, please? Thank you. Do you solemnly swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Ms. McMillan, would you please state and spell your name?
It's Amanda McMillan, Amanda McMellen.
Where are you employed and what's your job title?
I'm employed by the Missouri Public Service Commission as a Utility Regulatory Audit Unit Supervisor.
Are you the same Amanda McMillan who caused to be prepared testimony titled Direct Testimony of Amanda McMillan?
Yes.
Do you have any changes or corrections to your testimony?
I do have one correction.
What is it?
On page 2, line 15, I want to strike "and Mayor Sean Flower" and change the word "were" to "was," because he was not present at that meeting. That was my mistake.
Other than, with this change, is your testimony true and correct to the best of your knowledge?
Yes, it is.
And if I asked you those same questions today, your answers would be the same?
Yes.
Judge, we offer Ms. McMillan's testimony as Exhibit 112.
All right. Are there any objections? All right. Exhibit 112 is admitted.
And staff tenders the witness for cross-examination.
Okay. Mr. Van Gerpen, do you have any questions?
Nothing, Your Honor.
All right. Mr. Cooper?
Yes, Your Honor. Ms. McMillan, do you agree with Mr. Gately that generally property contributed or given to a utility or city by a developer where there is no CID would be included in rate base? Or in your experience, would you identify that as contributed plant?
Yes, we would.
Okay. if you were to estimate an annual revenue requirement associated with 2.9 million of Missouri American's rate base, do you have a back-of-the-envelope percentage that you would use for that? I mean, I've heard people that use 10% or 11% or, you know, whatever it might be to take into account, again, back-of-the-envelope, a rate of return on that plus something for depreciation. Do you have any sort of percentage that you use for that purpose?
As an estimation, typically about 10%.
Okay. So for 2.9 million, that would be about 290,000 would be the annual revenue requirement associated with that sort of rate base.
For the Arbor's rate base, correct.
Okay. And I suppose from rate case to rate case, that would also reduce, wouldn't it, as depreciation reduced the amount of plant on which the company was receiving a return.
Yes, that's correct.
But in year one, let's say it was 290,000, given the size of the St. Louis County district for Missouri American for water, something perhaps less than $1 per customer across the district. Is that the sort of magnitude that we're talking about?
That sounds about right, but that's just for Arbor's. That's not including the total difference.
Correct. Just isolating this Arbors piece.
Correct.
That's all the questions I have here.
All right, thank you. Are there any questions from the commission? All right. Ms. McMillan, I would ask you the same question that I asked Mr. Gately. Would it make a difference if those homeowners who bought lots in the subdivision had paid for those as part of their lot purchase or home purchase, if it's a completed home, as opposed to paying the assessments? Would your opinion be different as far as whether they're paying double?
And in my opinion, they wouldn't be paying double, but the staff calculation would remain unchanged.
Okay. All right. Ms. Van Gerben, do you have any follow-up questions?
Nothing, Your Honor.
Mr. Cooper?
Nothing, Your Honor.
All right. And any redirect?
Nothing.
All right. Thank you, Ms. McMillan.
Thank you.
Ms. Brest, do you have further witnesses?
We don't have any further witnesses. We do have 2 other exhibits that have been filed in EFIS. I would like to have them admitted. The first is the certificate of the state auditor and some attached documents we would ask to be entered as Exhibit 113.
Are there any objections to that? All right, Exhibit 113 is admitted.
And then the other exhibit is the affidavit of Sneha Darcy. She's with the St. Louis County Department of Revenue, and there's some attached documents. We would ask that to be entered as Exhibit 114.
All right. And that has already been filed in EFIS, correct?
Yes, both of these have.
Okay. Is there any objection to that? All right, Exhibit 114 is admitted. All right, do we need to take a break here?
Yeah, just a short one if you
All
would,
right.
Judge.
All right, let's break until about 5 till, and we'll go off the record. on the record. Mr. Cooper, call your first witness.
Thank you, Your Honor. We would call Sean Flower.
Good morning. Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Cooper.
Please state your name.
Sean Flower.
And are you testifying here today in a capacity for the city of Eureka?
Yes.
And what is that capacity?
I'm the mayor of Eureka.
And you testified in this case previously, correct?
Yes.
Have you prepared for purposes of today's proceeding rebuttal testimony concerning the arbors that is found in question and answer form?
Yes.
Your Honor, I would like to mark that for identification as exhibit number 14.
All right.
Mayor Flower, do you have any changes that you need to make to that testimony at this time?
No, it's accurate.
And thus, if I were to ask you those questions and your answers as reflected therein would be true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would offer Exhibit 14 and tender the witness for cross-examination.
All right, are there any objections to the admission of Exhibit 14? All right, Exhibit 14 is admitted. All right, Ms. Van Gerpen, do you have any questions?
Nothing, Your Honor.
All right. Ms. Bretz?
Nothing, Your Honor.
Okay. Are there any questions from the commissioners? All right, hearing none. Mr. Flowers, I have a couple of questions. Do you, or can we provide him with a copy of what was referred to as document 2U?
I can do that, Your Honor.
All right, thank you. All right, there, if you go to roughly page 7 and 8 of that document, would you agree that that's more or less a breakdown of the costs that were incurred for the CID when it comes to the Arbor subdivision, at least as of that date?
Yes, this is the schedule of, basically the developer was authorized to have certain classes of reimbursement, and this was their actual request to be reimbursed from the CID, the district.
And so would you agree that all of those assets that were constructed are part of the water and sewer assets that are to be sold to Missouri American Water?
So on the schedule that's attached,
Yes, on what is, well, let's just go to the,
it's the one titled the Parkfront Group LP. Am I looking at the right page?
right,
No, those are not all water assets.
okay. So there are, and I understand what you're saying, there is the asphalt trail and also streets and what have you.
Yeah, it looks to me on this, there was about a $590,000 for the street and the paving, and then there was another paving and trail that was, it's shown as, $48,000. So there was 640,000 or so that was non-water assets that were
Okay.
allowed to be reimbursed.
Okay. And then, but then the water system assets are part of what is being sold to Missouri American Water.
Yes, the rest of the costs were all associated with the water system.
Was there any part, or is there any part of the sewer system that's in the Arbor subdivision that's also part of the sale?
Yes.
What is that?
Well, there would be, in conjunction with the Arbor subdivision, a large section of sewer was constructed to tie in. There was a big line that was run underneath Highway 44, and then there's all the transmission system for sewer within the subdivision. So there are all sorts of sewer improvements that were, some are directly related to the individual homes in the Arbors, and some were related to hooking that subdivision up to the actual overall system that takes it back to our treatment plant.
And also, were there any lift stations constructed for that
I
subdivision?
do not believe they had a lift station. I believe that one is a gravity system through there.
And when those water and sewer system additions were completed, how were they transferred to the city?
Generally, what's done is on water and sewer, we'll go out, the city will inspect after they're complete, make sure that those systems are properly built. We'll get as-built plans that'll show that they've been built as designed, and then generally they're accepted at that point on a plat-by-plat basis. Sometimes a large development might have phases, but it stands now, as soon as it's done, they tell us this is done, we inspect it and accept it.
And how is it that you accept it? What's the procedure? Is it,
Generally, it's with the subdivision plat coming in, there's an approval process through that.
okay, no,
But it's basically through subdivision inspection too. We have a series of things, so we know it's eligible, but it's,
but not a formal resolution?
there's not one specific just to that.
Per the development agreement, and I don't know that you need to look at the development agreement, but it is Schedule 3.
It's at the end of the document.
Okay, I wasn't sure if you had given him that portion of it. But has a certificate of completion been submitted by the developer and accepted by the city and the CID?
I'd have to really look and see there's so many different certifications that go in and things that go on with this. I'm not sure I'd have to read that one to get a good answer.
All right. At the risk of getting off on a tangent, and I hope I'm not, but you're familiar with the engineering report that was used as part of the appraisal?
Yes.
Okay. If that engineering report referred to a lift station, and it's referring to the Arbor's lift station, with a building value of $350,000.
You could be correct on that. That may be, and it could be an oversight on my knowledge of a lift station there in that subdivision. I could, I guess, rephrase what I'm saying. I'm not familiar with that in there, but if that's what's in the engineering report, it very well could be accurate, and an omission by me.
Okay. All right, I don't have any further questions. Ms. Van Gerben, do you have any questions?
Nothing, Your Honor.
Ms. Bretz, any?
No, thank you.
Sorry. And Cooper, do you have any redirect?
No questions.
All right, thank you. Thank you, Mr. Flowers.
Oh, just put it on stack, it keeps it separate, thank you.
All right, Mr. Cooper, call your next witness.
Thank you, Your Honor. We would call Brian LeGrand.
All right, Mr. LeGrand, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Cooper.
Your Honor, we'll mark, or would like to mark, Mr. LeGrand's rebuttal testimony as Exhibit 15 for identification.
All right.
Please state your name.
Brian W. LeGrand,
By whom are you employed and in what position?
Missouri American Water. I'm the Director of Rates for Missouri.
And you have previously testified in this case.
I have.
Did you prepare for purposes of today's proceeding testimony, rebuttal testimony concerning the arbors in question and answer format?
Yes, I did.
If I were to ask you the questions contained in that exhibit today, would your answers as reflected therein be true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, at this time, I would offer Exhibit 15 into evidence and tender Mr. LeGrand for cross-examination.
Any objection? Exhibit 15 is admitted. All right, Ms. Van Gerpen, do you have any questions?
Nothing, Your Honor.
All right. Ms. Bratz.
Briefly, thank you. Good morning, Mr. LeGrand.
Good morning.
Do you have your testimony in front of you there?
I do.
Okay. Perhaps you don't have to refer to it, but do you remember writing in your testimony that Mr. Gately's statement that the Arbor's residents will pay for the water system twice, that's incorrect?
I do.
Okay. And that's on page 8, going over to page 9.
Yes, I see that.
Let's walk through this just briefly.
Sure.
So residents of the Arbors are paying SID assessments, right?
Oh, that's my understanding, yes.
And are you aware of how much the SID assessments are?
I believe it depends on the size of the home or maybe the size of the lot, maybe $500 to $700 annually.
If I said 500 to 800, that's in the ballpark?
Yes.
Right. Are you aware of how long they'll be paying those assessments?
I'm not.
If I said they'll be paying them for up to maybe 32 years, does that sound familiar?
I'm not familiar with the term, but I mean, yeah, I'm sure it's in the agreement, for the CID.
Okay. But you're aware that they will be paying these assessments for a number of years?
Yes.
And are you aware what these assessments pay for, generally?
Yes.
What do they pay for?
My understanding is that is to reimburse the developer for costs associated with some water infrastructure as well as some roads and other non-water infrastructure.
Sure, sure. So the residents of the Arbors will be paying for the developer's cost of the water system, is that correct?
Yes.
Okay. And then if Missouri American purchased the Eureka Sewer and Water System at $28 million, that $28 million will be incorporated in Missouri American's rate base, is that correct?
Yes.
And as part of that rate base, is it accurate to say that the ratepayers are paying for the water system?
The water system in its entirety, yes.
Okay, so they'll be paying twice for the water system. First through their SID assessments, and then second time through their Missouri American rates, is that correct?
No, I would disagree with that.
Okay, and what's your reason for that?
Well, when we get under the fair market value, appraisal approach, which of course is different than a net book value approach would be, where there's a if the company had not elected to use the appraisal methodology, the appraisal is for the entire system. There's not an appraised value for each specific asset, and that the appraisal price would then be allocated over the assets when it eventually goes on to Missouri American's books and becomes part of rate base. So if the determination was made that there should be zero value for these assets related to the Arbor system, that would mean that other assets would have a little bit higher value, but in total, the entire system would still be $28 million.
But the residents of the Arbors will pay the same rates as their other neighbors in Eureka, isn't that correct?
Under Missouri American ownership?
Right,
Yes, as they do today under the city's ownership.
sure. So they'll be paying for the water system through their rates?
Yes.
Okay, so they'll be paying through the SID and then through their Missouri American rates, twice.
I still don't see that as twice.
Okay, I don't have any other questions, thank you.
Okay.
Any questions from the commissioners?
No questions, Judge.
Thank you. All right, I've got a question. You are, and this is similar to my question to Mayor Flowers, but you are familiar with the engineering report that was used as a basis in the appraisal, correct?
Yes.
Okay. And in that engineering report, there was a City of Eureka asset value report, depreciated value assets in insurance list. And does that sound familiar?
Yes, I mean, it's been some time since I reviewed that report, but.
Okay. And so that list, it lists assets in the Arbor subdivision, and I just want to kind of go down the list real quickly. There's a well that was constructed, correct?
Yes, I mean, yeah, yes.
A $500,000 gallon storage tank, water storage tank, and a building that included water treatment mechanisms, for lack of a better word. Does that sound familiar?
Generally, again, I don't have the list in front of me, but generally, yes.
Okay. And also on the sewer system side, there was a lift station that was installed?
Yes, I mean, again, without reviewing it, subject to check, yes.
Okay. Mr. Cooper, those tables were not, have not been previously included in the exhibit that was the engineering report. Would you have any objection to those two tables being admitted as a commission exhibit?
I don't think so, Judge, but having said that, I'd like to see them so that I make sure I know what you're referencing.
Sure. Let's go off the record, and you may approach the bench. All right, after some investigation off the record, those tables are in the record as part of Mr. LeGrand's direct testimony, which is Exhibit 11. Okay, so Exhibit 11, Schedule BWL-3, pages 17 and 18, so there's no need to resubmit it as an exhibit. So, Ms. Van Gerpen, do you have any follow-up questions?
Nothing, Your Honor.
Ms. Brents?
Nothing.
Any redirect?
Very briefly, Your Honor. Mr. LeGrand, you were asked by staff counsel, Ms. Bratz, about why you say that the Arbor's customers will not be paying twice for the water system. Were you here earlier when Ms. McMillan testified?
Yes, I was.
And did you listen to her testimony concerning kind of a high-level estimate of what impact $2.9 million of rate base would have on the rates for the Arbor's customers?
Yes, I believe her estimate was approximately $290,000.
But-
Total revenue requirement overall, which would then be spread across 340,000 customers.
So something less than $1, would you agree with that kind of order of magnitude assessment of what impact this could have at worst on an Arbor's customers rate?
Yes.
Okay. That's all the questions I have, Your Honor.
All right, anything further for this witness?
No, Your Honor.
Vicky, you may be excused.
Okay, thank you.
Your Honor, I do have, I'll let Mr. LeGrand clear here. I was asked during opening statement about the overall vote for the Eureka resolution, and that can be found in Mayor Flowers' direct testimony, page 7, which is Exhibit 1 in the case, and reflects that there were 2,289 yes votes, which is approximately 67% yes, to 1,127 no votes, which is approximately 33%. And we have since then located the precinct-specific information, which we can file pretty quickly, probably by this afternoon, if you would like us to do that.
Okay, yes. And will that, is it obvious which precinct the Arbors is a part of?
I think we can
Waiting for a clicker.
I think we can make it obvious. I think there's a map that identifies the precinct, and then by that you can tell that that is the precinct that encompasses the Arbors.
Okay.
Judge, do you want to assign an exhibit number for identification for that filing?
I believe we are up to Exhibit 16.
Yeah.
So Exhibit 16 would be the results of the election broken down by precinct. And are there any objections to that coming into evidence? All right. Then, once that is submitted, it will be admitted into evidence.
Thank you, Your Honor.
All right, do you have further witnesses?
I do not.
All right. Do the parties need a break before closing arguments?
A short break would be great.
All right. All right, let's break for 10 minutes. We'll go back on the record at 10:35. Going. I'll take closing arguments, beginning with the staff. Ms. Pretz.
Thank you, Your Honor. I would like to just briefly remind the commission of the larger picture here. Sure, the people in Eureka voted to sell their systems to Missouri American. According to the testimony of Mayor Flowers, 2,289 people in the city of Eureka voted to sell the systems. The bigger picture is that the approximately 340,000 Missouri American customers in St. Louis County did not have that opportunity. They did not have the opportunity to examine the appraisals. They didn't have the opportunity to go to the town hall meetings. They probably didn't think of looking at the FAQs on the City of Eureka website. They didn't have the opportunity to ask Mayor Flowers questions. They had really no opportunity to make a decision whether paying more for the system's value was in their best interest. So 2,289 voters compared to the larger picture of 340,000 people, customers, is really a drop in the bucket. It's minuscule. And of course, it's pure speculation, but if given the choice whether to pay more than net book value for the systems, pay more for the systems than they were worth, I would imagine that a large number of those 340,000 people would say no. We don't want to do that, even if it's $1 a year, a month. There's no value to us there. The appraisal statute creates the potential of perverse incentives. Of course, the Eureka voters voted to sell their systems for $28 million. $28 million, $40 million, $50 million, it doesn't make any difference. They were unhappy with the quality of the water. They knew their sewer system was failing. They wanted to unload it. The more, the better. And that's what they got. What they're potentially being paid is more than what the system is worth. It also creates a perverse incentive for Missouri American. The stockholders of Missouri American are not going to pay for the increased value. In fact, they get rewarded for it because the increased value will be reflected in reflected in their rate of return. Sure, in the bigger scope of things, this potential purchase, will have a small burden on all ratepayers, but there's also a slippery slope argument here. Allowing Missouri American to purchase for $28 million, which is substantially more than what staff computed net book value to be, which has been, of course, the traditional way of basing rates, will encourage Missouri American to purchase more systems at inflated prices. This clearly does not create fair, just, and reasonable rates, and we ask for the commission to deny the application entirely.
All right, thank you. Ms. Van Gerpen, would you like to make a closing argument?
Yes, just briefly, Your Honor. Again, the OPC would like to remind the commission of its position that the commission should deny Missouri American Water Company's application for CCN to acquire the City of Eureka's water and sewer systems because the acquisition simply is not in the public interest. In making its decision, the commission must bear in mind that it is the commission itself, not Missouri American Water Company, who must determine whether the requested CCNs are necessary or convenient for the public service. Missouri American Water Company's decision to proceed under the appraisal statute does not change this fact. Here, if Missouri American Water Company acquires the Eureka systems, as it proposes to do, the residents of the Arbor subdivision will pay twice for parts of their water system, once through the Arbors of Rockwood Community Improvement District Special Assessment and once through their Missouri American Water Company rates. Today, we learned that the costs for reimbursement through the Community Improvement District are mostly for the water system, which will be sold to Missouri American Water Company. The residents of the Arbors will continue to pay their special assessment through approximately 2048. We also learned that Missouri American Water Company will place the system into rate base, which directly affects these customers' rates for their water service. Therefore, these citizens will likely pay twice for parts of their water system. For this and the reasons addressed in the OPC's initial and post-hearing briefs, it simply cannot be that under these circumstances, the acquisition is necessary or convenient for the public service. Therefore, the OPC requests that the commission deny the requested CCNs.
All right,
Thank
thank
you,
you. All right, Mr. Cooper, would you like to make a closing argument on behalf of Missouri American Water
I
Company?
would, yes, thank you, Your Honor. There's the argument that St. Louis County customers had no opportunity to approve or not approve this transaction. I don't think there's anything unique or unusual about that. That's true of every situation. Having said that, we addressed in our previous briefs potential rate impacts on those existing customers. We think that, to use Ms. Brett's word, any impact on existing water customers from this acquisition would be minuscule. And in fact, on the sewer side, there's likely benefits for the existing sewer customers. In regard to the process of arriving at the fair market value, it certainly is, what has been used is the process identified in section 393.320. It's the appraisal process itself. The use of certified appraisers, the use of more than one appraiser, I believe, continues to be a buffer and a good judge of what the fair market value of water and sewer assets are in this case. I think therein kind of lies the fundamental disagreement that we have with staff. In its closing, it again mentioned the comparison of the net book value, which is a purely regulatory rate-making term, to the fair market value. These things are two different things. We've talked about that before in this matter and in our briefs, and would ask the commission to keep that in mind as it moves forward. I think the one additional fact that we did not have quite as specifically at the start of the day that we have now through testimony is that even if, and we don't agree with this, but even if one wants to view the Arbor's residents as paying twice for assets because of the Missouri American rate, the amount of, or the annual revenue requirement associated with $2.9 million of Missouri American rate base is likely to be less than $1 per year that those Arbor residents would end up paying. So it is a extremely small amount at worst, even if one wants to look at it in that fashion. Beyond that, Your Honor, I would just refer you to my opening statement. I don't think anything would change from my opening statement based upon the evidence that was taken today. And very much thank you for your time.
All right, thank you. Are there any other matters that need to be addressed before we adjourn? All right, then this evidentiary hearing is adjourned and we are off the record.